The Senate will please come to order. It's my pleasure this Friday morning to welcome the Reverend Standard Baker of the Cathedral Church of St. Paul Episcopal of Burlington to the chamber virtually to give this morning's devotional. Welcome, Reverend.
Good morning. I'm Standard Baker, clergy person at St. Paul's Episcopal Cathedral in Burlington and Archdeacon for the Episcopal Diocese of Vermont. It's good to be back with you, even by Zoom. I treasure the times I've offered the Senate devotional over the past years. I'm going to start this morning with a prayer for wisdom and unity for elected officials from the Episcopal Book of Common Prayer. Loving God, send down upon those who hold office in this Vermont Senate the spirit of wisdom, charity, and justice, that with steadfast purpose they may faithfully serve in their office to promote the well-being of all people. And grant, O God, that your holy and life-giving Spirit may so move every human heart, and especially the hearts of those in this chamber, that barriers which divide us may crumble, suspicions disappear, and hatreds cease. That our divisions being healed, we may live in justice and peace. We ask this in the name of all that is. Amen.
Amen.
Last week, I told some of our parishioners at the cathedral that I was going to offer the devotional and asked what they thought I might say. Their message was simple. Most offered some version of this. Tell them that this is a time when we need clear and brave leadership. We need voices that remind us of who we are, and without ignoring the real challenges we face, also remind us that there is hope ahead. And one person added, remind them to take care of themselves. We need them. And I agree, all of you have much to do in historically challenging times. Times when our divided society needs guidance and healing. Take care of yourselves. Nurture yourselves. Spend a moment outdoors or inside for quiet reflection. Pray, meditate, walk, exercise, read, look at and listen to nature, breathe. Refueling by each of you taking care of yourself, and all of you listening to and supporting each other will garner the energy and wisdom you need to lead us. I opened with a prayer and now I close with a short poem prayer called Clearing by Martha Postlethwaite that I received on a card this Christmas season. She writes, do not try to save the whole world or do anything grandiose. Instead, create a clearing in the dense forest of your life and wait there patiently until the song that is your life falls into your own cupped hands and you recognize and greet it. Only then will you know how to give yourself to this world so worthy of rescue. Amen. Godspeed.
Thank you, Reverend. Thank you. Are there any announcements this morning? The senator from Bennington is recognized. Good morning, Senator. I'm going to kindly ask you to share your words with the room.
Yes, thank you, Madam President. I'm unmuted. I would move that the rules be suspended for the purpose of relieving the Senate Judiciary Committee from S-250 accountability for law enforcement officers for the purpose of transferring it to the Committee on Government Operations.
Thank you, Senator. The senator from Bennington has moved that the Committee on Judiciary be relieved of S-250 and that the bill be committed to the Committee on Government Operations. Are you ready for the question? Kindly unmute. All those in favor, please say aye.
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 Those opposed, nay. The ayes have it, and you've relieved the Judiciary Committee of S-250 and committed the bill to government operations. Regarding S-210, being on the calendar for notice and affecting the revenues of the state under Rule 31 is referred to the Committee on Finance. I believe we have two House bills for reference. H 74, an act relating to making miscellaneous changes concerning self-storage business, introduced by Representative Marcotte, which passed the House on January 19th. Please listen to the first reading of H74.
H74, an act relating to making miscellaneous changes concerning self-storage businesses.
You've heard the first reading of H74, and the bill is referred to the Committee on Economic Development, Housing, and General Affairs. Thank you. H627, an act relating to the Vermont Economic Development Authority, introduced in the House by the Committee on Commerce and Economic Development and passing the House on January 19th. Please listen to the first reading of H627.
H627, an act relating to the Vermont Economic Development Authority.
You've heard the first reading, and the bill is referred to the Committee on Finance. Excuse me. Thank you. I believe that concludes our House bills for reference today. We do not have any Senate bills, and we will proceed to the orders of the day. We have on the calendar for action S74, introduced on February 19th, 2021. It was referred to the Committee on Health and Welfare, which reports it has considered the bill and recommends that the bill be amended as appears on pages 262 to 265 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of S74.
S74, an act relating to modifications to Vermont's patient choice at end-of-life laws.
I'm pleased to recognize the Senator from Addison, Senator Hardy, for the report of the Committee on Health and Welfare.
Thank you, Madam President. In 2013, the Vermont Senate took the historic step of being the first legislative body in the country to pass the bill to permit people diagnosed with a terminal illness to request regulated medical assistance to hasten their own death. The bill that would become Act 39 was reported on the Senate floor by my predecessor, the then senior senator from Addison, Senator Claire Ayre. Madam President, may I read from Senator Ayre's 2013 bill report?
You may.
To quote, "The goal of this legislation, patient choice and control at end of life, is to allow dying Vermonters more autonomy and control during their final days. It allows them to participate on their terms and in the way they lived their lives. They can involve their families and take comfort that their suffering will end quickly. They can create a harmonious, loving, peaceful passage at the end of their life and ensure that anyone seeking doesn't have to die alone, and that everyone who participates is on solid medical and legal basis. It is a bill to bring more choice and control to mentally competent, terminally ill Vermonters and face the final stages of the dying process." Madam President, 9 years later, based on the experience of many Vermonters and their families, the goals articulated by Senator Ayre in presenting the original bill are being achieved.
Senator,
Enabling more.
I'm going to kindly ask, there's quite a bit of background feedback coming from someone's office, and so if you're not speaking, kindly mute yourself. Senator, you may continue. Thank you.
Thank you. It may also be my dog who is actually, I apologize. But 9 years later, based on the experience of many Vermonters and their families, the goals articulated by Senator Ayre in presenting the original bill being achieved, enabling more people choice, control, and peace at the end of their lives. Act 39 was largely based on Oregon's 1994 death with and requires a strict multi-stepped process to prevent abuse by medical providers and others, and to ensure informed patient decisions about options. Act 39 allows Vermont physicians to prescribe Medication. My internet connection is unstable. Apologies. Vermont physicians to prescribe medication to a Vermont resident with a terminal condition with the intent that the medication be self-administered for the purpose of hastening the patient's death. Act 39 set forth conditions for the patient and physician act to be lawful. Conditions include, but are not limited to, an oral and written request by the patient to the physician.
Excuse me, Senator Hardy, we are losing quite a bit of your report right now, I think due to a broadband connection. The senator from Windham is recognized.
Madam President, is it possible that the senator could turn off her video while presenting and come back on when she votes?
This is a question for the parliamentarian.
And we allow the senator from Addison to give her report without video, but to appear again on the screen when it's time to vote.
The senator from Windham has moved that the rules be suspended for the purposes of allowing the senator from Addison to turn off her video due to a poor broadband connection to continue her report, and then be allowed to turn her video back on for the purposes of voting, which would be consistent with the rules. Are you ready for the question? Kindly unmute. All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and the senator from Addison shall be permitted to turn off her video for the purposes of continuing her report, with the understanding that she'll turn it back on before voting consistent with the rules.
Thank you, Madam President. Is this better? Can you hear me better?
It is. Thank you.
Thank you. I will go back a paragraph and start. Act 39 was largely based on Oregon's 1994 Death with Dignity Act and requires a strict multi-step process to prevent abuse by medical providers and others, and to ensure informed patient decisions about end-of-life options. Act 39 allows Vermont physicians to prescribe medication to a Vermont resident with a terminal condition with the intent that the medication be self-administered for the purpose of hastening the patient's death. Act 39 sets forth conditions for the patient and the physician for this action to be taken lawfully. These conditions include, but are not limited to, an oral and written request by the patient to the physician, instruction that all steps in the process must be voluntary, ensuring that the patient be capable of making such a decision, confirmation of the diagnosis and prognosis by a second Vermont physician, and an attestation that to these steps by a non-interested witness. The process also includes the provision of information, verbally and in writing, of diagnosis and prognosis, treatment options, feasible end-of-life services, including palliative and hospice care, range of results and risks of taking the medication, and that the patient may rescind the request for medication at any time. Once the prescribing physician fulfills all the statutory requirements, the physician must report to the Department of Health that all steps have been taken. The filing of the report confers immunity on the physician from professional, criminal, or civil liability associated with the treatment of the patient for the hastening of the patient's death. According to the January 15th, 2022 biannual report from the Department of Health, from May 2013 to June 2021, 116 Vermonters had taken advantage of the provisions of Act 39 for the purpose of hastening their own death. As required by the law, all of these individuals had been diagnosed with a terminal illness, including 77% with cancer, 11% with ALS, 5% with neurodegenerative conditions, and 7% with other terminal illnesses. On average, just fewer than 15 Vermonters per year have used the Act 39 medical aid in dying provisions to hasten their death. Others may start the process but not finish it for a variety of reasons, including that their quality of life remains acceptable or because they become too ill to participate. There have been no validated reports of abuse since the passage of Act 39. The passage of Act 39 and ensuing support, education, and advocacy have also improved the overall knowledge of end-of-life choices and services in Vermont. According to a 2021 Department of Health report, use of hospice services has increased 26% since 2013, and now nearly half of all people dying in Vermont use these services. Vermont was the first state to enact a medical aid in dying law by legislative action, and the second state overall to have such a law, as Oregon passed the law by ballot initiative in 1994. Now, 11 states, including the very large California, have such a law. Thus, both here in Vermont and nationally, much has been learned about the process and results of these laws. Many patients and their family members have reported that the law and process have provided them with comfort and control during an extremely difficult time. However, over the almost 9 years since its inception, several provisions have been identified that are unclear or overly onerous for people during their final stages of life. Thus, S74 proposes to make very modest changes to the process and clarify provisions of the law for certain medical professionals. So let's turn to the language of the bill, which can be, as the Madam President said, found on page 262 of today's calendar. Section 1 includes a couple new definitions that are used in updating the bill, including a clarification of the meaning of healthcare services and a definition of telemedicine that may be used in some clinically appropriate instances. And this definition of telemedicine is consistent with the definition used in other parts of the statutes. Section 2 updates the requirements for a patient requesting medication to aid in the patient's death to allow for the oral request to be made in person or by use of live audio and visual telemedicine. If the physician determines that the use of telemedicine is clinically appropriate. The requirement remains that 2 such oral requests by the patient must occur at least 15 days apart, and all legal provisions related to patient consent and use of telemedicine apply. Experience has shown that by the time a patient reaches the point to request medication to aid in their death, it may be physically difficult for them to travel to meet a physician in person. For people in more remote parts of the state, the distance to their physician may require several hours of travel, which may cause suffering for people already weak and in pain. Particularly over the past 2 years, the use of telemedicine has become easier to access and acceptable to use, and both patients and doctors have become more adept with the technology. At the same time, clinical practice has determined when telemedicine is and is not appropriate. Thus, S74 allows for the use of telemedicine using both audio and visual when clinically appropriate to request medication to aid in dying. Section 2 also clarifies that the physician prescribing the medication to aid in a patient's death must determine that a patient is suffering from a terminal condition based on both the patient's medical records and a physician's physical examination of the patient. This section also removes a provision that requires that the physician wait 48 hours to write the prescription after these 2 oral requests and offering an opportunity to rescind the request. In practice, this 48-hour waiting period has not proved necessary and has prolonged the suffering of patients who are ready to hasten their own death and created an unnecessary weight and burden for patients and families during an extremely difficult and painful time. Finally, this section makes language regarding the patient and physician non-gender specific. No other changes to the strict 15-step process required by Act 39 for prescribing medicine to hasten death are made. Section 3 of the bill clarifies that no physician, nurse, pharmacist, or other healthcare provider would be subject to civil or criminal liability for acting in good faith compliance with the law. The current law makes this clear for physicians and is implied for other medical providers. S74 makes it explicit for all healthcare providers. This is particularly important because only one pharmacist in the state, located in Rutland, currently provides medication for medical aid in dying due to liability concerns, creating access challenges for patients in many areas of the state. Section 4 states that the bill will take effect on passage. The committee vote was 4-0-1 in favor of the bill, and we heard from a number of witnesses, including a professor of family medicine and palliative care at the Porter Medical Center, advocates for Patient Choices Vermont, Compassion and Choices, and Vermont Right to Life, staff members at the Attorney General's Office and the Department of Health, as well as Blue Cross Blue Shield Vermont, and of course our own legislative counsel and the sponsor of the bill, the senator from Windsor, Senator McCormick. As many of you know, the former majority leader of the other body, Willem Jewett, died last week at the age of 58. Just over a year ago, Willem was diagnosed with a rare cancer, mucosal melanoma. And after many months of fighting, his condition deteriorated to the point where last month, he began the process of requesting medication to hasten his own death. And just days before his death, Willem advocated for the passage of S74, saying that in practice, he found some of the Act 39 restrictions on patients and providers, particularly the 48-hour waiting period and multiple in-person requests, to be obstructive and, quote, completely meaningless. Madam President, if I may quote from an article in VT Digger about Willem Jewett's death.
You may.
Willem states, if anyone wants to suggest that I or anyone else who's gotten to this stage hasn't thought long and deeply about this, and if they've made the request, hasn't done it with information, or at the end of the day, conviction, they're crazy. It's the fundamental authority of the individual over the most fundamental decision they'll make in their life. It becomes simple if you accept that premise. Willem died with the help of medical aid in dying, surrounded by family and friends, on the very day that your Health and Welfare Committee began work on S74. As many of you know, Willem Jewett was a friend of mine. I've known him since our college-age daughters were in preschool together and served on a school board with him for several years. He lived just up the mountain from me, which in Vermont makes us neighbors too. Willem was an incredible human being. And as a member of the other body, Willem Jewett worked hard to pass Act 39 in 2013, not knowing that he himself would use the law in 2022. So today, Madam President, I ask the Senate to pass S74 in memory of Willem and his incredible life. Thank you, Madam President.
Thank you, Senator. The question is, shall the Senate amend the bill as recommended by the Committee on Health and Welfare? I'm going to ask, because I think there are going to be some questions, Senator Hardy, if you want to stay off camera, so should there be issues with broadband again, that we will make sure that you come back on before there is a vote. So I see that there's a hand raised. The senator from Rutland is recognized.
Thank you, Madam President. May I inquire of the reporter of the bill?
You may.
Thank you. I may have heard you incorrectly, Senator Hardy, but when you reported the vote of the committee, I believe you said 4-0-1. And in fact, I believe it should have, unless I'm mistaken, I believe it should be read 4-1-0 for correction.
Thank you, Madam President. You are correct. I believe, misstate the vote, and it should be 4-1-0. My apologies. I mixed up the X, Y, and Z that Secretary Bloomer spoke about to us the other day. My apologies. Thank you, Madam President.
Thank you.
Are you ready for the question? The senator from Franklin is recognized.
Thank you, Madam President. And I join with the senator from Addison in mourning our colleague, Representative Jewett, and the difficult struggle that he faced. I do have a question, and I would ask that I may inquire of the reporter.
You may.
As I look at this amendment in Section 2, Paragraph 5, which relates to the determination of the physician. It says that the physician, and it's referred to the prior paragraphs, may make a determination by telemedicine in terms of prescribing the lethal medication. But it goes on in paragraph 5A to strike the physician's physical examination of the patient. And it substitutes, among other things, of a physician's physical examination of the patient. Does that imply that the physician in our previous bill is required to be who administers the lethal medication, is required also to have conducted a physical examination of the patient? Does this revision mean that the physician who dispenses the lethal medication, even in his 2 visits, may have done both of them by telemedicine, but also does it mean that that person has potentially never even examined the patient at all and is relying on the examination by a physician who may be someone else who is not otherwise named?
Thank you, Madam President. The language in paragraph A in section 5 is to ensure that the physician who is prescribing the medication to hasten in the death of a patient has examined the patient's medical record and verified that a physical examination of the patient has taken place based on the examination of the record. And the two visits with the physician to prescribe the request the medicine may take place via telemedicine if that physician believes that it's clinically appropriate to do so. So at any time, a physician may say, I don't feel that it's clinically appropriate to do this via telemedicine, and I would like to see you in person, including for a physical examination. But this provision does state that the physical examination could have been done by another physician and documented in the patient's medical record.
Thank you, Madam President.
The senator from Bennington is recognized.
Thank you, Madam President. I'm just reading section 2 of the bill, which provides that no person shall be subject to civil or criminal liability or professional disciplinary action for acting in good faith compliance with the provisions of this chapter. My concern, I thought during the report you indicated it was just pharmacists, which actually I don't have a problem with, but I'm not sure who we're bringing in here is no other person, no person. And who else is intended with this language to be brought into this?
Madam President, I believe, are you looking at the strike all amendment?
I guess I'm looking at the bill as introduced that was provided by the Senate. I don't have the strike all amendment.
The strike all amendment is on page 262 of today's calendar. The language, I believe the language you're referring to has been modified by the committee.
Okay.
So I would suggest it's now in section 3 of the strike all bill that's in our calendar. And it says no physician, nurse, pharmacist, or other person licensed or certified or otherwise authorized by law to deliver healthcare services. That's
Yeah,
the language that we did amend in the committee, the no other person language that you're referring to.
Okay, well, thank you for that clarification, but it's still rather broad. And it goes much beyond the pharmacist. When your report indicated it was the only problem area was the pharmacists. And I'm concerned about how broad that could be.
If I may, Madam President, we got testimony from the Attorney General's office that in practice, currently, the way that the Attorney General's office interprets the current law is that all of these providers who are licensed medical providers in the state would have the benefit of not having the criminal or civil liability if they act in good faith. However, it wasn't as explicitly stated for these other medical providers in Act 39 as it is for as it is for physicians. So this S74, as amended by the Health and Welfare Committee, makes current practice explicit in the area of liability. The issue has been brought up explicitly for pharmacists because that is an access issue, but there are other medical providers who are reluctant to participate because of liability issues. So this makes it much more explicit that they are all included, even though in practice that has been the case since the passage of the law.
Thank you, Madam President.
Are you ready for the question? The senator from Caledonia is recognized.
Thank you, Madam President. First, I'd like to say I appreciate the presenters making a connection with Willem. He was somebody that I also worked with on a couple of different joint committees, but I am also cognizant of my own history with this bill when it was originally presented by the current presenter's predecessor. Some of the older members may recall that my mother had died a couple of months before this. And one of her last requests was to ask me to vote against this principle. As a libertarian, I had myself in conflict on that day to the point where this became quite an emotional experience for me. One of the things that really bothered me was then Senator Ayer's insistence that an individual who was making this decision would have literally hands-on contact with the physician who was assisting them through the process. And what I find as a lawyer here is the explanation about paragraph 5 in section 2, making a disconnect. And I don't find clarity in the previous physician's physical examination actually having any relevance to the question of whether the individual is subject to a terminal condition. I know that's the intent, that's the hope, but I am extremely nervous about disconnecting a person who has hands-on medical experience with the patient, because the main argument that was made at the time was that we were being extremely careful with how someone would take this step. And so I want, for Willem's benefit, to say, I want to make things easier for those in this position. But I'm having a very difficult time stepping away from what was an original intent of making sure that people were making this decision based on their and their doctor's personal relationship and a decision to make what obviously is one of the most important decisions a person could make. Thank you, Madam President.
Thank you. Are you ready for the question? The question is, shall the Senate amend the bill as recommended by the Committee on Health and Welfare? The senator from Chittenden is recognized, the senior senator.
Thank you, Madam President, and thank you to the senator from Addison for her very clear and complete report. Some of us, you know, have been involved with this issue since the early 2000s when the bill was first introduced. And I'd like to give credit to Dick and Ginny Walters, who were very much engaged in bringing the concepts of death with dignity to the state and then now patient end-of-life choices for patients. The original bill, as for the bill passed Act 39 in 2013, was not without controversy, nor is it without emotion. And I think we see that each day as we think about those who have accessed the program outlined in Act 39. Madam President, people who access this program are patients with a terminal illness, have been through a great deal of struggles and suffering, and worked with many different healthcare providers. Their last decisions have been thought through for many years. This is not a decision that is made lightly, nor without communication with families and friends. Madam President, I would like, if I could read some quotes, 2 or 3 at the most, from patients who have accessed and utilized the process outlined in Act 39 and now modified with technical corrections in S74. May I read, Madam President?
You may.
And the first one is from Representative Willem Jewett, who has been identified recently because of his work as a legislator and because of his commitment to passing the law in 2013. I'd like to quote from an interview that he gave shortly before he died. He said, "I'm not sure if I have a day, a week, or a month to live, but Act 39 has given me peace of mind all the way through. It's quite an effort when you get to the condition that I'm in right now, getting out to a doctor's appointment. It's hard. What got me passionate about this bill back then, was the patient control. At the end of the day, the patient really needs to have control. Let's side with the patient. I'm proud of this one. It's a good bill." And his reference there is to S74 that is before us today. I'll read one more quote, Madam President, if I may.
You may.
D. Allen was a former resolutions clerk at the Vermont House. Some of you knew that in December in 2021, you might have known her, but she was dying from an aggressive neurodegenerative disease. And her doctor had advised her that her disease would cause progressive debilitation, where she would lose both mental and physical capabilities, including the ability to take end-of-life medication, and that she would face an excruciatingly painful death. I will quote here from an interview that she gave regarding the 48-hour delay that is being struck in S74. Dee says, "The hardest part was waiting the 2 weeks and then the 48 hours for calling in a prescription. For crying out loud, why? It's a time that can make it so that you don't have access to the law. And I'm timing this very closely. I just have to make it to Monday." And her son followed up, about the 48-hour waiting period, that those 48 hours were a nightmare, and just the sheer emotional toll that it took on his mother was painful to watch. Mr. President, Madam President, with my, I owe something in the kitty, I'm sorry. But Madam President, I ask my colleagues in the Senate to please vote in support of S-74, listening to the words of patients who have utilized the program over the past 8 or 9 years, and to move this forward to the House, to the other body. Now, thank you, Madam President.
Thank you. The question is, shall the Senate amend the bill as recommended by the Committee on Health and Welfare? Are you ready for the question? Kindly unmute. All those in favor, please say aye.
Aye.
Those opposed, nay.
No.
The ayes appear to have it. The ayes do have it, and you've amended the bill as recommended by the Committee on Health and Welfare. The question now is, shall the bill be read the third time? Are you ready for the question? The senator from Chittenden is recognized.
Thank you, Madam President. I should know better than to follow up on the impassioned speech from the senator from Addison, but I just want to briefly talk about two personal situations that occurred in my life. As you know, many of you served with my late wife, Sally Fox, both in the House or in the Senate. And she was a strong supporter of Act 39 in 2013. And as you know, she passed away before being able to return to the Senate in 2014. I was present when she went to her doctor, her cancer specialist, and started the process of Act 39. For various reasons, she didn't complete that process. In addition to Sally, I actually was hired in my former life to promote this bill in the 2000s, and it was by Dick and Ginny Walters who were mentioned to me. And Dick naively said, well, he had spoken to Senator Lyons and he thought they could get the bill all the way through the House and the Senate in 4 months. Well, 11 years later, the bill finally passed. His naivete was only surpassed by his doggedness and the support from his wife, Ginny. And I want to say that they both actually utilized Act 39 themselves. And Ginny Walters just passed away a little bit more than a week ago utilizing Act 39. And these people were amazing people and fought as hard as possible over a dozen years to see this law enacted. And I wanted just to acknowledge Ginny at this point. Thank you.
Thank you, Senator. Are you ready for the question? The question is, shall the bill be read a third time? Senators kindly asked to unmute. All those in favor, please say aye.
Aye.
Those opposed, nay.
No.
Ayes appear to have it. The ayes do have it, and you've ordered third reading of S-74. We have on the calendar today for action S-183, introduced on January 4th, 2022. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as appears on pages 265 to 267 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of S-183.
S-183, an act relating to Midpoint Probation Review.
You've heard the second reading, and now the chair is pleased to recognize the senator from Windham, Senator White, for the report of the Committee on Judiciary.
Thank you, Madam President. Over the past few years, the Judiciary Committee and the Judiciary Oversight Committee have been working on what we refer to as justice reinvestment. Not to go into detail, but this initiative has helped us to rethink much of our judicial and corrections system. We are all grateful to Senator Sears for not only setting us on this path, but for keeping our feet to the fire. One of the goals was to make sure that those who have run afoul of the law are not incarcerated or kept on probation any longer than is necessary. So S-183 starts on page 265 and addresses the probation part of this initiative. S-183 concerns Midpoint probation review, a process through which the Department of Corrections reviews the record of every person who is serving a specific term of probation in order to determine whether or not the person should be discharged. The review takes place 30 days before the probationer reaches the midpoint of the probation term, hence the name Midpoint Probation Review. Last year, Act 24 enhanced the midpoint probation review system in several ways. Under Act 24, the Commissioner of Corrections reviews the probationer's record 30 days before the midpoint and is required to file a motion with the court to discharge the probationer from probation if the commissioner determines that a certain listed criteria are met. Under prior law, before Act 24, the commissioner had discretion as to whether to file the motion. In addition, Act 24 required the court to grant the commissioner's motion and dismiss the person from probation unless the court found that the probationer was not complying with certain probation conditions or that releasing the probationer would endanger the victim or the community. S-183 brings the midpoint probation review back to the legislature in order to respond to a recent court decision which made two findings that must be corrected. First, it permitted probationers with pending, it found that permitted probationers with pending criminal charges to automatically participate in midpoint review. Secondly, it held that Act 24 was not retroactive, which meant that it only applied to persons who were put on probation after the effective date of the act, which was July 1st of 2021. Both of these conclusions were contrary to the legislative intent of the original bill, and S-183 corrects them. Section 1 of the bill makes it clear that a probationer who is subject to a pending criminal charge is not automatically able to participate in the midpoint probation review process. Instead, the commissioner is provided with discretion and may file the motion to dismiss the probationer from probation, but is not required to. Section 1 also provides the commissioner with the same discretion about filing the motion if the probationer is subject to a pending complaint for violating probation. Sections 1 and 2 also clarify that the midpoint probation review program is retroactive. As a result, all persons currently on probation will have the opportunity to participate in the program, not just persons who are placed on probation after Act 24 took effect. This retroactivity provision includes a technical piece as well, specifying that if a probationer has already reached the midpoint, then the commissioner will conduct the review as soon as possible. This language is necessary because if the midpoint has already passed, then the commissioner obviously cannot do the review 30 days beforehand, as the statute generally requires. Section 3 provides that the bill takes effect on March 31st, 2022. The expectation is that the bill will move through the House quickly and be signed by the governor right away so that it can accomplish its original purpose of reducing the probation population. We heard from Al Cormier, from the Chief of Operations at the Department of Corrections, Dale Crook, the Director of Field Services for DOC, Nicholas Demme, the new Commissioner of the Department of Corrections, Evan Meenan, Deputy Director, State's Attorneys and Sheriff's Department, Matt Valerio, the Defender General of the Vermont Defender General's Office, Judge Thomas Zone, Chief Superior Judge, and Eric Fitzpatrick from Legal Counsel. The committee vote was 5-0-0, and we ask for your support. Thank you.
Thank you, Senator. The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? Kindly unmute. All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've amended the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read a third time? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've ordered third reading of S 183. I believe we'll now move to confirmations. We do have one confirmation on the calendar. We have an appointment reported out of committee to take up for confirmation. This is the appointment of Matthew Valerio of Proctor as Defender General for a term of 4 years. I believe this is a reappointment. The question is, shall the appointment of Matthew Valerio as Defender General be confirmed by the Senate? I believe the report will be made by the Senator from Caledonia. Senator Benning is recognized.
Thank you, Madam President. Madam President, Matthew Valerio was first appointed in 2001 under then Governor Howard Dean. Most folks don't really know a lot about the position of Defender General, but the job itself is kind of a check on law enforcement, a check on prosecutors, ensure that the Constitution is adhered to, and in the operation is dealing with about 22,000 cases a year that come through the criminal justice system and the family court system by way of juvenile and chins cases. The upshot is that for the 21 years that he has now been a Defender General, having been reappointed through Governors Douglas, Shumlin, and now Phil Scott, he has remained within his budget for 21 years without a budget adjustment. That is a phenomenal situation for a government individual in charge of an organization of this size. When he began, there were a very limited number of folks who might have carried a cell phone. And if you think back at the early days of his own career, they were still dealing with rotary phones and a typewriter. And that was how things got done in a law office. Today, there's an internet. We obviously know about computers. All attorneys under his wing must be technologically savvy in order to get documents not only generated from their own office, but filed within a court system that is dealing with something known as Odyssey filing. His position is currently facing challenges. There are lawyer shortages, especially in the rural areas of the state. The non-lawyer staffing is also in short supply because they literally cannot find people for either the lawyer positions or the non-lawyer positions. There are a wave of people who are leaving because most of the lawyers within his system have reached the wonderful age where I happen to be, and that is on the verge of closing down practices. Current challenges also include the fact that Vermont brings in 2.5 more kids into the court system and into state custody than does our neighbor over in New Hampshire. Asked why he would want to continue tackling this job at his age, he says he has no lack of energy and no lack of interest. More importantly, I have an unfortunate love of the fight. In his free time, Matt happens to play guitar. I also happen to play guitar. But when he told us that he actually owns 43 guitars, I had to think that I don't think I've ever seen a music store in Vermont that has that many guitars in it at any one time. And he's doing all the things that he's doing in the midst of a pandemic, which, as we all know, is quite remarkable. Our committee vote was 5-0-0, and we would ask for the Senate's support at his reappointment. Thank you, Madam President.
Thank you, Senator. The question is, shall the appointment of Matthew Valerio as Defender General be confirmed by the Senate? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've confirmed the appointment of Matthew Valerio of Proctor as Defender General. I believe we're ready for a motion. The senator from Wyndham is recognized.
Thank you, Madam President. Pending announcements, I move that the Senate stand in adjournment until 9:30, Tuesday, January 25th.
The senator from Wyndham has moved that, subject to any announcements, the Senate do adjourn until Tuesday, January 25th at 9:30. Are there any announcements this afternoon? The senator from Washington is recognized.
Thank you, Madam President. Senate Finance will meet at 1:30.
The senator from Caledonia, Senator Benning, is recognized.
Thank you, Madam President. Institutions will meet at 1 o'clock.
The senator from Wyndham is recognized.
Thank you, Madam President. The apportionment committee was scheduled to meet at 12:15, but I would ask everybody to gather their lunch if they want to and try to meet 7 minutes after the fall of the gavel. We have some business to attend to today. And government operations will meet at 1 o'clock. Thank you.
Thank you. The senator from Bennington is recognized.
Thank you, Madam President. Senate Education will meet at 1:30.
Thank you. Are there any additional announcements? Seeing none, the senator from Wyndham has moved that the Senate adjourn until Tuesday, January 25th at 9:30. Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and the Senate stands adjourned until Tuesday, January